For an institution that relies on the public believing and trusting in its integrity and honesty, today a seemingly, potentially important step. The Supreme Court of the United States announced that it has adopted a new code of conduct, a move it seemed forced to make following the extensive news reporting over the past several months exposing allegations of ethics lapses by some of the justices. At the center of those reports, Justice Clarence Thomas, who was gifted expensive trips from a billionaire friend and Republican donor named Harlan Crow, who incidentally also purchased the property that the justice's mom lived on and that Crow renovated, all of which Thomas did not disclose. Justice Sam Alito also did not disclose a pricey trip he was gifted years ago from a billionaire friend, which brings us to today's news. The highest court in the land putting in writing that justices are required to, quote, uphold the integrity and independence of the judiciary and, quote, avoid impropriety and the appearance of impropriety in all activities. The introduction to this new ethics code provides this context, quote, the absence of a code, however, has led in recent years to the misunderstanding that the justices of this court, unlike all other justices in this country, regard themselves as unrestricted by any ethics rules. To dispel this misunderstanding, we are issuing this code, which largely represents a codification of principles that we have long regarded as governing our conduct. Despite that proclamation, what the code is missing is any way to enforce the ethical standards the justices insist they've always abided by, but we, the public, seem to have a different perception of. As Senator Sheldon Whitehouse of the Judiciary Committee responded this afternoon after this news broke, quote, an updated ethics code with no means to enforce it still leaves a gaping hole for mischief. This court, and this court alone, the supposed guardian of due process, still exempts itself. That is where we start the hour with Senator Sheldon Whitehouse of Rhode Island. So I will admit to feeling emotional when I saw this. Yay, they're listening. They read newspapers. They've seen Senator Whitehouse on television, and all of the sort of Cuba Gooding Jr., Tom Cruise, you know, from Jerry Maguire, help me, help you, has gotten through to them. But even their statement feels like it's us that misperceive their ethical lapses. Tell me your thought of today's news.
Well, it's a really strong signal from the court that they get how badly their standing has fallen and how serious the legitimacy crisis is that they are experiencing. At the same time, they also try to say that this is, for the most part, not new, and it's largely what we've always done, and nobody should really worry. So, you know, they're a little bit spongy about that. The important thing here is that while they've said, okay, we're going to adhere to the rules of baseball, what they have not said is, and we're going to allow umpiring. We're going to keep calling our own strikes. We're going to keep calling our own base running, whether we're safe or not at second, irrespective of what the facts are, with nobody neutral having a look at it and with no serious fact finding. That's the big hole that remains, and that's where the work remains to be done. And I hope that the court will see that and move on to that next step of deciding, like every other circuit court of appeals, here's how we're going to enforce our code of ethics.
Let's keep the baseball thing going. It does feel very significant, though, that they've agreed to play baseball, right? Like on a field with bases and to wear the uniforms. Do you think there's any opening here to talk about umpires?
Yeah, I think that there is. I mean, they have said in their announcement that they're looking to the other courts for advice on other measures. What those other courts have is the process for making a determination about whether a justice has broken the rules or not. And it's super simple stuff. It's not super complicated. It's where's the inbox to file the complaint? It's who sorts out the crazy complaints for the legit ones. It's who does the investigation and fact finding for the legit ones. It's once you have the facts, who compares them to the rules to see if the rules have been followed. And then who tells what the result was. That's all super simple stuff, and all other courts do it. So I think there's a real pathway for them to follow if they can suck up the courage to defend their institution by doing it.
I will draw on my time in the Republican Party to explain what might be going on inside. I imagine the folks that were for this step feel like they just climbed Mount Everest, like, oh, my God, we got the naysayers, you know, to the peak, and you want more. What is, in your view, sort of what is sort of the balance that you have to do as someone so steeped in all these issues and with the court?
I think there's a lot less balance here than the court seems to perceive. It's not hard for the court to decide, here's where the inbox is for complaints. It's not hard for the court to hire people to sort through them and to hire staff attorneys to do basic investigative work to determine what the facts are in relation to a complaint. It's not hard to set up a panel of very distinguished federal judges to say, guys, we've looked at the facts and we've looked at the rules and they don't line up this time. Just want you to know that if this were our court, we'd call a foul here. This would break the rules. And to make that report public so that everybody knows that there was an answer at the end of the day. It's very simple stuff. Other courts do it. They can too. And I think while there is that feeling of, phew, we just summited Everest, and I think there's some really reluctant people who don't like, and we're not going a step further. I do think it's inevitable that they have to go that next step further. Now that they've adopted rules, they have to have a mechanism for enforcing them. And
I assume it's not, I mean, let me just read what is in it's called the Supreme Court Ethics, Recusal, and Transparency Act of 2023. It requires Supreme Court justices to adopt a code of conduct. It creates a mechanism to investigate alleged violations of the code of conduct, which is what you're describing. It improves disclosure and transparency when a justice has a connection to a party or amicus before the court, and it requires justices to explain their recusal decisions to the public. It does not look like any of this looks backward. Is that your sense?
I think they are very much eager to only look forward. There's a proceeding in the Judicial Conference right now to determine whether they should look backward with regard to the rule about personal invitations from resort owners being treated as personal hospitality. And the larger question of looking backwards, I think, remains very much alive. We in the Judiciary Committee, I believe, I haven't canvassed the whole committee today, but I believe we still want to go forward with the subpoenas. The public is entitled to know what happened, how many gifts there were, from what billionaires, to whom, under what circumstances, organized by whom, and put the story together, because it's an important story to tell, particularly because it bears on the political decisions that the court has been making. You can't separate those two things.
That was my next question for you. Will the committee proceed in pursuing the subpoenas for Harlan Crow and Leonard Leo?
As I said, I haven't canvassed the members yet, but I think Chairman Durbin is eager to proceed. I certainly am. And our process is to reschedule after the avalanche of obstructive amendments that we got so that we're prepared for it next time and can deal with it and go on to the important vote, which is the one on the subpoenas.
Right. And I mean, in terms of what is in front of the court this term, these questions are very much relevant.
Yeah, they're very relevant. And by the way, we have two of the billionaires already cooperating. So it's not as if we're doing something that's so improper that nobody will cooperate. Right. And the ones we're still looking at are Harlan Crow, who you mentioned, and Leonard Leo, who has been the functionary for the billionaires and was behind the Trump Supreme Court list. And it was involved in and traveled with Alito on his fishing trip and was sitting with Harlan Crow with Thomas in his backyard where the painting was made. So these are people who are deeply, deeply enmeshed with the court right-wing justices.